You've got an idea or invention, but you have zero clue on how to protect it. Filing your first patent can feel complicated, but I'm going to make it simple today. Step 1, you want to validate your patent eligibility. Before you spend your time and money, let's confirm if your idea qualifies. There are 3 tests for determining whether your idea is eligible. First, it's got to be new. Now, new is fairly straightforward. It just means that there's nothing exactly like your invention out there. It also needs to be useful, which means it must serve a function, must solve a real problem. The third test is non-obviousness. This is the more difficult one to meet. Essentially, what this means is that there must be something a bit unexpected in your invention. So an example is that you have a new phone charger that you've devised, and it's got a different type of circuitry that results in it performing better than existing phone chargers. And that increased functionality could make it eligible for a patent if it's new. In other words, it hasn't been done before. If it's non-obvious, meaning whatever the modification is, that it's kind of outside the range of expectations, and that it's useful. And the last thing is called patentable subject matter. And that just means that it's the right type of thing to be protected. So like you can't protect a business idea because it doesn't have patentable subject matter, but you can protect something that has working parts or a physical one-piece item like a shovel that performs a function, or a combination of ingredients, could be a new hair care product. To determine when something is new and non-obvious, what you need to do is perform a patent search at the USPTO, United States Patent and Trademark Office, to determine what else is out there that's similar, because that's going to help you figure out, is it new, is it non-obvious? Step 2, let's figure out whether you're doing a provisional or a non-provisional patent application. A non-provisional patent application is also called a utility patent. Now, a utility patent, it's a grant from the United States Patent Office that allows you to stop other people from making, using, or selling your invention. And a non-provisional patent application is a rather complex document. It takes a lot of skill and experience to prepare correctly. And the description has to meet the full legal requirements for how a patent is presented to the United States Patent Office. And also, that description must adequately protect your invention. It must be written in a way that defines what is the uniqueness and prevents people from copying that uniqueness rather than just copying the details. And so it costs more to do a non-provisional patent application. And for that reason, sometimes people want to start with a provisional patent application instead. Now, a provisional patent application has a lower upfront cost, but what it does is it establishes a priority date. It establishes a filing date. So when you file that, you get priority over other people, even people that have filed the full patent application after you. When you file that provisional application, you have 1 year to complete the process and file the full patent application. In other words, the non-provisional or the utility patent application. A lot of times people like to file a provisional application first because it's great for doing your product market fit testing. In other words, you want to be able to test the idea in maybe a somewhat public way, but you want to be secure first. Another advantage of filing a provisional application is when you've got the core of the idea figured out, but you know that there's a lot more to it that you will be developing. Here's a simple rule of thumb. If you're at an early stage and at a limited budget, then you might want to do a provisional patent application. If you're fully launching, if you're getting ready to get your product out there on the market, then you might consider filing a non-provisional now. Step 3, you want to prepare the required documents. What's essential is that you have a written description of your invention, a very good written description of your invention, and also detailed drawings or diagrams that go along with the description. And then for a non-provisional patent application, you need claims. That's the legalese that describes exactly what's being protected, exactly what the territory is that you're seeking to prevent other people from infringing on. The claim section is where most DIY patents go wrong. Even if you think you've written a great description for your invention, you definitely want to have a skilled patent attorney advise you with regard to the claims. But we'll come back to this a bit in step 6. The next step is you file the patent application with the USPTO. Here's how beginners actually file. You go to uspto.gov, that's the United States Patent and Trademark Office, and you can file your application online there, right on the website. The filing fee for a provisional application is going to vary depending on the size of your organization. So for big companies, I mean companies with more than 500 employees, they're going to be spending more than $1,000 on the initial filing fee for a utility patent application. For a small entity, you'll be paying about $600 for filing a utility patent application. And there's also something called a micro entity, which are really more of the beginner inventors, people who filed less than 4 non-provisional patent applications in the past. And the micro entity fees are approximately half of what those small entity fees are. So roughly around $300 for filing a non-provisional application. If you file a provisional patent application, then the fees are significantly less. It's going to be somewhere between $75 and $150 for filing the provisional patent application. A pro tip is you definitely want to check your entity status and the requirements for that entity status before you file your application. One mistake that beginners make is sometimes paying too much. They pay the small entity fee when they're actually entitled to pay the micro entity fee. So double check your eligibility. And how long should this take? The time to actually file the application on the website is probably a couple of hours at worst. If you've done it a few times, then it could be as little as 10 to 15 minutes. And the next step is you've got to respond to office actions. So after you file your non-provisional patent application, the application will be assigned to an examiner and it will be reviewed to see if it meets all of the requirements, to do research to find out what the closest prior art is to it, what the closest other inventions are to it. And then an examiner will either accept your application or reject it. And when they reject an application, that's called an office action. And the office action will give all of the details of the rejection, all of the reasons for the rejection, regarding the content of the application and regarding what other patents and other prior art it's being compared to arrive at this rejection. But now, since most patent applications do receive an initial rejection, you shouldn't be discouraged by this, because we have the opportunity to respond to the rejection. And when we do, there's a decent chance that we can get the patent approved. But the patent office is busy, and all the examiners at the patent office are busy. And so the time frame for having your application get that first review by a patent office examiner is often 12 to 36 months. But you definitely want to be prepared for answering those office actions when they do come. And when the office actions come, you need to stay on top of the deadlines. There will be a time for response. And if you don't file that response within the time frame allowed, which is typically 3 months, then your application will be abandoned. The next step, of course, is to hire the right person to help you. Most first-time inventors shouldn't go it alone. And here's why. First of all, a poorly written patent application is going to definitely lead to a rejection, or it's going to lead to weak protection. Now, let's look at who you can hire to help you with this. First of all, there are patent agents and also patent attorneys. First of all, a patent agent is someone who's qualified to represent individuals to help them through the patent process. They're typically engineers or scientists that have passed the patent bar examination by the USPTO, but they're not attorneys. Patent attorneys are those individuals who, first of all, they went to law school, they passed the state bar exam, but they also passed the patent bar exam. They're also qualified by the United States Patent and Trademark Office to represent individuals in patent matters, and they can help them with trademarks and other things aside from just patents. Now, how do you choose a patent agent or attorney? First of all, you might look to people that have some technical expertise that pertains to your invention. You definitely want to confirm that they're registered with the United States Patent and Trademark Office, because an attorney needs to be actually registered to practice before the United States Patent and Trademark Office to file your patent paperwork. And be sure to check client reviews and testimonials to make sure that people have had a good experience with this patent attorney, with this patent law firm. One way to select a good patent attorney is by looking at their writing, even in their correspondence with you, when they write to you, when they talk with you, even if they text with you. If you see that someone really isn't a good writer, then they're probably not going to be a good patent attorney either. If you don't already have someone you trust, you can book a free strategy call with my team. We'll walk you through what's patentable, and we'll help you get the process started the right way. What's your biggest question about filing your first patent? Drop it in the comments below. I read each comment and reply personally. but don't include any confidential information about your specific project in that question. And make sure to grab my book, The ABA Consumer Guide to Obtaining a Patent. It's like having a patent attorney in your back pocket. Now that you know how to file your first patent application, here's the next step. Watch my video right here where I break down exactly when not to patent your idea. Because to be honest, not every idea deserves a patent.